Then come to the modes of dissolution. Dissolution of a company we brought about in any of the following ways: through transfer of company undertakings to another, under the scheme of reconstruction or amalgamation. In such a cases, the transfer company will be dissolved by an order of the tribunal without being wound up. That this is already discussed with you all in respect of amalgamation, in respect of reconstruction, in respect of mergers, acquisitions, and this we already discussed with you all in respect of procedures involved in the winding up the company. That procedure is winding up, and the end result is the company is dissolved. And so, through the winding of the company, the assets of the companies are realized, the liabilities are paid off, whatever due to the companies, whether long-term liabilities or short-term liabilities of the company, whether working capital of the company in the form of unworked capital of the company, in the form of share capitals of the company. This is shown on the assets and liability side of the balance sheet of the company. And you have to, because if you have to close all the related postings and fixed accounts, the balance sheet you have to close. And finally, we have to make a utilization account and payment of all the liabilities, whatever you realize from the sale of assets. That amount has to be used for the purposes of payment of liabilities, and surplus, if any, is distributed to the members of the company in accordance with their rights. Then difference between dissolution and winding up. Winding up is one of the methods by which dissolution of a company is brought about, and it is a legal entity of the company, continues at the commencement of the winding up. So there's a difference between, I already explained you, there's a difference between dissolution and winding up process. So the winding up is one of the method of dissolution of the company. So end result is dissolution. The process is winding up, and the end result is dissolution of the company. And that discontinue your legal entity of the company after your winding up process. You discontinue to be a separate legal entity concept, and discontinue to be artificial legal person in the eyes of law. So after your discontinuation, after your winding up, you no more longer act as a company in the eyes of law, cannot enforce your cases after your dissolution, after your winding up in the eyes in the court of law, because you are no more longer an entity in the eyes of law. So you have to, before you winding up, you have to close all the books of accounts, have to whatever case is pending on you, you have to clear all the cases. Then you have to close books of accounts, and then if any surplus left, must be distributed among the members of the company, shareholders of the company, as per their shareholders in the company, as per their shares, as per the number of shares in the company. So the company, after winding up company, ceases to be a legal entity, ceases to enjoy the characteristics or features of separate legal entity concept that is applicable to the case of companies, whether it is public limited by nature or private limited company. Separate legal entity concept is a very important characteristics or nature of the company, and company continues to do its business at the commencement of winding up. And company will be allowed to continue its business so far as necessary for the beneficial for the winding up of the company. Then again, continuation of difference between dissolution and winding up. Dissolution is the end result of winding up. Dissolution brings about an end to the legal entity of the company, and company ceases to exit business operation, business entity, separate legal enterprise, limited liability, that is of its members of the company. So after its dissolution, they are no more longer the members of the company. They are no more longer the shareholders of the company, directors of the company. After the dissolution of the company, the company ceases to exit on its dissolution, and company is set to be dissolved when it ceases to exist as a corporate entity. On dissolution, the company name shall be strike off from the register of companies, and we shall also get this fact published in the official gazette. Thus, the dissolution just puts an end to a life of the company. Official legal life of the company, that is official life, legal existence in the eyes of law, in the court of law, in the case of any dispute, any arguments, any cases pending in the court of law. Company can be present in the court of law as a artificial legal person, as documentary evidence, and in the form of common seal, in the form of the company represented by its members of the company, by directors of the company. They are the eyes, ears, the nose, face of the company, brain of the company. So they are acting on behalf of the company. So they are responsible for company's responsibilities in respect of the dissolution of the company, in respect of the binding of the company. And thus dissolution just puts an end to the existence of the company. In coming to conclusion, binding up of a company under Indian law refers to the process by which a company is dissolved and its assets are sold off to pay its liabilities and debts and distribute whatever balance remains among the shareholders of the company, members of the company. And the law governing as per the Companies Act, previous Companies Act 1956, and the new replaced Act, Companies Act 2030, that is an amendment in the year 2013, that is a new act, new Companies Act 2013, that governs the um, binding process of the company, that regulates the binding process of the company, certain rules and regulations, procedures involved in the binding of the company, that is law governing the binding of the company as per the Companies Act of 1956, that is the previous company law, and the new amended act enacted in the year 2013 as applicable to the company for the purpose of binding the company. So it is important to know that binding up does not necessarily mean that the company has failed or incapable of running a profitable business. In some cases, it may be the most practical solutions for resolving issues that cannot be resolved through other means. The process can be lengthy and complicated, requiring the involvement of various stakeholders, such as shareholders of the company, creditors of the company, and liquidators of the company. So that is a process has been involved, cognitive process has been involved in respect of the binding of process, lengthy process is involved for binding of the company, and there are so many stakeholders involved in the process of binding. Uh, in the capacity of shareholder of the company, creditors of the company, liquidators of official liquidators of the company, and whatever issue, any case is pending with the company, that must be resolved before winding up, so that we can, that is a very smooth winding up, clear winding up of the company, smooth and efficient winding up of the company. So company tries to make all possible solutions for resolving the issues, any pending cases with the court of law before officially end the life of the company by fulfilling all the legal formalities in respect of dissolution of the company. The tribunal has the authority to order winding up on various grounds, such as failure to pay debts, just and equitable causes, mismanagement, and fraudulent conduct. And it is necessary to take steps to ensure that company assets are appropriately valued, creditors' claims are settled, and the remaining assets are distributed among the shareholders of the company. So so tribunal has authority. Tribunal means I just explained these lines to all of you for explanation of these terms used in this concluding remarks of this particular session of today class. Tribunal, the winding up of the company. What is you understand all about the winding up of a company? That is the meaning of winding up, concept of winding up, genesis of winding up, the procedures involved in winding up, and the modes of winding up, the difference between winding up and dissolution. What is winding up? What is dissolution? What is the difference between these two terms? And the, the procedures involved and the conclusion. So tribunal means here means that national company or tribunal has authority to order winding up on various grounds, such as failure to pay debts, just and equitable causes, mismanagement, and fraudulent conduct. It is essential to take steps to ensure that the company assets are appropriately valued, creditors' claims are settled, and the remaining assets are distributed among the shareholders. So in conclusion, we say uh, binding up of the company under Companies Act 2013. This is new company law 2013. The complex procedures involved, that is, you have to understand all the pros and cons involved in respect of the closing of the company, business of the company, because after closing, the artificial legal existence of the company ceases to exist after closing, and the member ceases to be a member of the company, ceases to be shareholder of the company after company ceases to exist. So it is necessary to settle all the dues and clear all the pending cases laws, and then distribute whatever balance remains among the shareholders of the company. So by this I went up. Thank you all.